all sorts of good stuff happening here tonight.
I would like to welcome Alan Elkins, family attorney
Glad to
from
be here.
Fort Lauderdale, and you have offices where else?
We have offices in Palm Beach County and Boynton Beach, the Palm Beach Gardens, and then we're also up in the Orlando area.
Wow, big practice.
Now,
try.
I seen your website. I like the cartoons and stuff.
Thank
It's
you.
really
It's
cool.
brand new.
Really cool. Let's set this up before we do the interview. Let's talk a little bit about what's going on right now with this.
Well, as you may know, that the family law section, the chair of the family law section came out with a press release last week, or a week ago Friday, stating that family law, that permanent alimony really isn't permanent. And on Wednesday of last week, I was on WLRN, where I had a little bit of a debate with an attorney named Barry Finkel, who was saying, well, it's so easy to modify and it's so easy to change in circumstances, not to worry. And the outcomes that I see by reading cases daily, tons of cases, just don't coincide with what they're saying. So I'm not sure how I connected with you, Alan, if it was...
The way that I got involved, I actually saw an article in the Sun Sentinel, and it was written by Alan Fisher.
Yes,
And I actually took the initiative to call him. You know, I followed the legislative session last term, which of course it didn't pass in the Senate, and the bill died. And I thought that it has a lot of merit to it, and I know there's a perception that most attorneys are not in favor of the changes, and I don't know that that's accurate, but I'm one of the attorneys that certainly is in favor of the
and that's really nice to know, because that, you know, right now we're just hearing from the leaders of the family law section, but there are a lot of family law attorneys who are fair-minded, and they want what's best for their clients and for the public, and that's why I invited show, because he can share some of his opinions and views, and why, from a legal standpoint, why what we're asking for Florida alimony reform. So the first question I would like to ask you, Alan, is why do you support reforming Florida's outdated permanent alimony laws, and why is now the right time?
Okay. Well, let me just back up briefly to say I've been doing this a long time, 30 years plus. And over the years, you tend to see a significant difference from judge to judge, from court to court, from county to county, and having the perspective that I do, having offices literally throughout the state. I've litigated cases all over the state, and I just think that it makes a lot of common sense to have some uniformity, so that when you go in front of a judge, you have at least a realistic expectation of what that judge is going to do. Now, on a personal note, I pay permanent alimony. I have a 20-year plus marriage. I pay. I'm not thrilled to be paying. It's a fact of life. Would I like some relief? Yeah. Is that what motivates me? No. I've been remarried 10 years, and, I always get the questions, why are you paying so much, and how long is it going to continue? So, I think I bring a unique perspective to the issues here. So I've seen it, and I must say in my practice, I represent as many women as I do as men, and I see in many cases, too, where women pay the men. So, they want the same equality. So it's for that reason I picked up the phone. I spoke to a gentleman from the alimony reform, this Alan Fisher. He called me, and here I am.
Well,
Excellent.
glad to have you.
I think we have a call on the air. Tim, are you there?
Yes, I'm here.
Tim, you're on the air. How can we help you?
I was calling. I'm a part of the Florida alimony reform, and I'm an alimony payer myself, and I was one of the ones who is a victim of the court system, and a judge who said she had a bad day, and that's the reason why my alimony was increased, had upward modification.
And what is upward modification? What does that mean?
Upward modification, one side goes in there and proves it. It should be up for a variety of reasons. Maybe he's making more money. Maybe she has a greater need in place now. You have the right. Court always retains jurisdiction to modify spousal support.
And Tim, what in your case was it justified for the increase?
Well, no. What happened is my ex-wife. We were married for about 4 years, or I'm sorry, we were married for 9 years, and when we were divorced, because our incomes were the same, she was just awarded $1 alimony. And so after 4 years of divorce, she decided that she needed a new car, so she took me to court to upward modify, because she needed a new car. She didn't have any proof of what a new car would cost, how much it cost to repair her old car. She just wanted a new car. So my alimony went from $1 a month to $600. So after giving her extra $600 a month, her income turns out to be twice as much as mine monthly. But yet the judge still did it, and the judge said she was having a bad day.
And the judge said she was having a bad day?
Yeah, I seriously doubt that the judge would say she's having a bad day.
I could see she was, though. And is that typical if, his case, $1, I could see $1, okay. I understand that case.
Yeah, what he's saying is that the court left the door open, and that's what they did by putting in $1. It didn't say no alimony just for that reason. That's one of the things that's actually addressed in the new reform, or at least in the bill that's currently pending.
Well, it keeps people on the hook in the court system for litigation, for future litigation. And that's what happened to Tim, I'm supposing. And if she has more money, why should he be paying for her car payment?
I know, and the judge went, there's written law even now before the reform that says that the payer's income should not be substantially lower than the payee's income, and that's written in black and white, and the judge just ignored that.
Well, see, this is the beauty of if you have these laws that we're talking about where there's some uniformity, you're not going to have a specific judge saying, what they told you, and then a judge down the hall saying something different. And exactly. At the most basic level, which dawns on me, at one time we didn't have child support guidelines. Now we have specific guidelines. You make this, you pay this. And there are factors where you can deviate from it, but if that has helped us so much in determining what child support should be, because again, it was the same story. Go in front of one judge, he'd say something else. Somebody else in another area might come up with a different number. So it's the same thing that I want to see applied to alimony, so that you don't have the differentiation between the judges.
It's funny you mention that, because when I sat down with the family law section back in December, the leaders, David Mans, Karen Porras, and a few others, they mentioned that they did not like the guidelines of child support.
Well, I can't fathom that. I believe that, but
that's what was said.
They're the best thing that ever happened. It's never going to change.
Which leads me to my next question: why are the leaders of the family law section so opposed to fair laws, what we're proposing? Because we're not
at least change.
We're not proposing to end alimony.
Well, let's not use the word fair, because that's interpretation. What about change?
My answer to that is you have to look at the nature of the beast to some degree, and I'm not saying all are motivated, by their own self-interest, but if you were to have guidelines, I personally believe it would be easier to settle cases. It's just one less thing that the parties are going to fight over. Right. That's strictly my opinion, but look, are there some attorneys out there that litigate for the sake of litigating? Sure. We all know who it is. In fact, just so you know, with this proposed bill, I got a letter that was sent to me by another attorney who I'm friends with, and there were probably about 30 people on the letter talking about the proposed changes and for their feedback and this and that. So I'm not going to sit here and say that they walk in, in a lock goose step, but I get what you're saying. But I think that there are many more that agree, as I do, maybe less vocal, but it is what it is. I think that it's just a matter of time. There is going to be reform.
Now, I have a real quick. Tim, are you still there?
Yeah, I just wanted to interject something else, too. And going back to the original divorce, we went to mediation. And at the mediation, my lawyer, I didn't want to pay alimony, obviously. And during the mediation, as we're all trying to compromise and try to negotiate, he says, let's go ahead and just agree to $1. Just agree to $1 now. And I didn't want to. He says, well, if you go in front of the judge, I guarantee you'll pay more. So what do? You're kind of like strong-armed in mediation to settle for that dollar, even though you didn't want to, because he doesn't, he's telling you want to pay more if you go in front of the judge.
But Tim, thank you for bringing that up, because that's what I have heard, that people that people are saying, well, you agree to it in mediation, it's an agreement, blah, blah, blah. But to tell you the truth, people do get strong-armed in mediation because they get scared that they're going to go to court and be told they're going to pay more on top of having to spend thousands of dollars for a trial.
Now, do you take an attorney into mediation?
Yeah, let's clarify. First of all, I'm a huge proponent of mediation. Most cases, or a good majority of cases, do get settled through mediation. It gives the parties the opportunity to fashion their own agreement, so you take the judge out of the equation. So that's a good thing. Now,
if two people are logical.
Amen, including the attorneys too. Listen, there are some attorneys, and I want to say this nicely, don't know one part of their body from another, and it's very difficult to try to resolve a case with an attorney that doesn't have a clue. I find the easiest cases to settle are the ones where the attorneys have a realistic expectation. Now, having said that, the clients too. I'll be the first to tell you, some clients, I can give my advice. Do they have to follow it? No. And I say the decision's theirs. The worst thing you want is a case of buyer's remorse, where you get the phone call the next day, why'd you have me do this? I don't want to do this. Do I have to? We've all heard it. So, you're as good as the counsel that you're getting. That's why you hired him or her. So I hope in your case, I would have told my client, if it looked like there was a realistic chance of you getting nailed with alimony, maybe that was the thing to do. On the other hand, if you were my client, I probably would have said something like, you're leaving the door open, and that's not always a good thing. So at least, for instance, under this Reform Act, there's a certainty of what's going to happen. So that's the beauty of the situation.
And you know what? With the certainty, it's good for both parties. First of all, if you're the recipient, you know how long you're going to receive alimony, and you know that you need to work on your education and your job skills and your career to build yourself up to become self-supporting. And there's reward in that, both emotional and financial, naturally. And for the payer, they need to have a light at the end of the tunnel. They can't just pay indefinitely. It's so demoralizing for people.
Every case is different. They're fact specific, but you can make some generalities. And again, I think, in having been invited to come here at some point, and maybe it's not tonight, but we should actually talk about what the specific changes are being proposed, at least the major ones.
Well, let me bring up three of the major ones. First of all, we want whatever changes that are being proposed to be retroactive, so that all the people that are suffering under the current laws right now have a chance to reclaim their lives. That's number one. Number two, we are looking for a default judgment of 50% the duration of the marriage, unless there are clear and convincing circumstances that a person needs alimony for longer. And there are cases where that might exist, and we don't want to close the door for that either, to be fair. And the other thing is the right to retire at federal retirement age, or whatever the normal retirement age is for your particular profession, where a person does not have to pay alimony out of their retirement, which is really unfair.
Now, does any of this really have a snowball's chance, and where, to pass?
I think so. Listen, it's not like, this is Greek. I mean, these statutes exist in other states. So right. It's Florida just getting, up to snuff. And, what was just mentioned, it's not only the duration, which was just talked about at least there's some limit. And I personally believe that if there were limits, that might actually encourage more marriages, because going in, at least you'd have some idea that it's not going to be forever. Exactly. So that's one thing, is the duration. And then also, importantly, it's the amount. At least there's some guideline in place, because everybody's heard the story that, I'll get a question from my client, why is so-and-so paying this amount, and why is this one paying that amount? So what you're doing, you're actually basing it on a percentage of the net, not to exceed a certain amount. So to me, at least from my standpoint as a practitioner, I like the idea that there's duration. I know how long it's going to be paid. And just as was just said by Debbie, there are exceptions to every rule. So God forbid there's a disability of some nature that has to cause it to be extended. It can be extended. So you're looking at some duration limitation, and then you're looking at the amount. Just as this guy said, why should she have more than I have? And although it's a general proposition, absolutely true. The payor shouldn't have less than the payee receives. So at least the guidelines that have been proposed at least talk about specific amounts and tie it to the length of the marriage.
So I got a sensitive question.
Sure.
Again, and we're being honest here.
Yeah.
Your representative, your attorney, it really comes down to having the best you can get, yes? If you're going, let's be honest. If you're going to have a guy who's going to go in there and is not going to give you everything you need to know, you're going to start behind the 8 ball.
Yeah, you listen, are you at a disadvantage if you don't have the money to hire legal counsel? Yeah, there's some truth to that, but at the same time, more expensive doesn't mean better. You don't want somebody that's going to sit there and churn the case.
Knowledgeable.
Some guys that do that. Mm-hmm. So you got to hope you're getting a fair shake. And you were talking about mediation before. You hope that you get a mediator that knows what they're doing so that the mediator can kind of steer you in one direction or the other.
Yeah. But let's not forget the cost of mediation. Between 2 attorneys and a mediator, you're talking at least $1,000 an hour to mediate.
Well, again, I'll give you for instance. Okay, when I mediate, as a general rule, my mediators, and I only use a couple of them that I like, on average might be $250 an hour. So the parties are splitting the cost of mediation. And then to that, you're right, the hourly that the attorney's charging. But even if you go to a mediation that it lasts 3 to 4 hours, the bottom line, you're still typically better off than if you have to try the case.
Well, that is true. Definitely,
so
that is true.
You got to look at the whole picture.
If it's a successful mediation.
Yeah, but lifetime alimony could be hundreds of thousands of dollars. $1,000, I'd rather weigh it out.
But right now, if you're married 17 years or longer, even in mediation, you're told you're paying permanent alimony. Isn't that correct?
Well, again, it depends on the respective finances of the parties, but yeah, what you're talking about is there is a presumption of permanent, and of course, permanent means permanent unless one of the parties dies, or then you get into the issue of cohabitation. It was written into the statute where alimony can be reduced and or terminated provided you meet that criteria. So that's another hot button. That's
a hard thing to overcome. And people double dip; they cohabitate and collect permanent alimony for life, and there's no justice in that.
Interesting. And this debate will continue until it passes.
It will pass. It will
pass. Well, and it depends on what's going to pass. Is it all going to pass? Is it going to be chopped up? If
it's not retroactive, nothing's going to pass, because we can't ignore the people who are suffering right now.
Honey, I got to tell you, before you came along, they were ignoring them for a long time. I think...
I'd like to interject something in there right there.
Sure.
When you're talking about suffering, everybody, it's all relative on how much you make. So, some people may think $600 isn't a lot of money, but after I was forced to pay or, ruled to pay the $600, 2 or 3 months of that in trying to survive, you get behind on your mortgage. So I went at 2 or 3 months, 4 months paying that to filing bankruptcy, and luckily was able to modify my mortgage just so I could stay at my house. They would have foreclosed on that.
Well, that's crazy.
Yeah, and let me just interject as a side note, talking about bankruptcy. Of course, if you have an alimony or child support obligation, that's not dischargeable in bankruptcy. So thank goodness.
No, but it's to what the $600 went to before.
Right.
You don't have that money. So that's what the the bankruptcy for. Is for all the other, not the alimony.
See, but these are the people we're trying to help here, and it's not a gender issue, because I speak to women who have these problems too.
I agree with you, Tim. My only advice is Alan's in studio. Write down his number, and to be honest with you, I think you need different representation. I think you need something that's a little bit more up in your alley.
Alan, why don't you give your number and website?
Yeah,
I appreciate that. It's Elkins and A-N-D Friedman, Freedman, I like to think that we're reasonable. I like to think that we treat people the way that we would like to be treated. And like I say, I've been through it. I pay it. I represent both men and women, and I get it. And hopefully there'll be more people like me. And I do believe this bill ultimately will pass. It's just a question, just like was said, is it all going to be as is proposed? Probably not. There'll be some give and take, but it would make things a heck of a lot easier for everybody.
And I feel like Alan is just a blessing from the heavens for us. And the reason is because it's the first time that I've ever heard an attorney say to me that people need to be treated the way they want to be treated. And that to me is monumental.
Absolutely.
But a lot of attorneys don't feel that way.
No, I understand that. And
They
that's
don't
one of the
care.
problems
You're
that
a
you're going to
number.
be facing, because those attorneys are the ones that are going to give you a hard time or not going to care.
Right.
So my advice to Tim on the line here is, pick up a pen, make a phone call, and get some information, and get these wheels spinning in the right direction for a change, and see what happens.
That's right.
Now, again, no guarantees. There's no guarantees in anything.
There's no guarantees in anything, but if these laws pass, or I should say when these laws pass, things will be a lot easier. Do you realize divorce is up there with death in terms of stress level?
Well, usually one follows the other. All right.
Listen, if you invite me back here one day, I'll be glad to share
Absolutely.
stories as permitted to by the clients, and then I think it might be helpful to the listeners to actually go over some of the information that's actually in the
Do you want to
statute.
hang
So I'll
in
be
for a
glad to
few
do that.
minutes? We have Lori on the phone.
You have Lori on the phone. And can you give? I just got a tweet. Can you give your phone number again?
Yeah, the phone number in Broward is 954-772-6014, and in Palm Beach it's 561-738-5988.
All right, Tim. Thank you for calling. Let's talk to Lori.
Right.
Lori, you're on the air.
Hi.
Hi, Lori. How are you? It's Debbie.
Great, Debbie. How are you?
Good. How are you? Lori Barkis is an attorney in Weston. She's I've seen her ads, actually. She practices a lot of collaborative law, which I think is a really good thing. And she is on board with a lot of our issues that we're trying to change. And one of the things that Lori wrote to me is she is very concerned how litigation hurts families. So, Lori, would you like to address that?
Sure, Debbie. I'd be glad to. Basically, as an attorney and also as a mediator, one thing is pretty much indisputed. If there's litigation, there's conflict. And when you have people who are divorcing and they have children, no matter how much they try to keep their children out of that conflict, which some people do, some people don't, the children experience that conflict. And if you have prolonged litigation that goes on for years or longer, the children experience that. And the end result is that everybody experiences that conflict, and it's inevitable that that family, individually and in totality, is going to be harmed by that.
Right. And even with adult children, I notice how there are so many adult children that are almost forced to take sides in this issue, and there are so many parents that are estranged from their children because of this, because they take sides. Have you seen that a lot in your practice?
I have definitely seen that, and I would agree with you, because the older the children, the more likely that there will be siding with one parent or another. And absolutely, I would agree that in a lot of cases the family does become divided.
Yeah. And another thing that Lori wrote, which I thought was very awakening for me, was I always say that the recipient, the permanent alimony recipient, has no responsibility essentially for their own financial well-being. And Lori did write that to me, and she wrote something else that piqued my interest. That not only do they not have responsibility to earn a living, but they don't have responsibility to preserve assets. And I know, I keep saying these words. I know a lot of cases because I do, and where the 401ks are split through Quadro and the monies are squandered by one party, and then it's time to retire and, hey, they don't have the money. Can you elaborate on that, Lori?
Yes, absolutely. Basically, as we all know, at the time of divorce, whatever assets exist that are considered marital are split equally between the parties. And if there's alimony awarded at that time, you look at the recipient's ability to earn income, and you would base that on what they have earned in the past or what they're currently earning. But if there's a modification in the future, the only thing the recipient needs to show is that he or she does not have the ability to meet their needs. There's no looking at what the recipient has done, whether they've tried to further their income, whether they've preserved assets, what they have done or haven't done to put themselves in a better position, so to speak.
Right, and I think that's a very old-fashioned way, especially if you're looking at from a male payer to a female payee type of perspective, where the little woman at home didn't know anything about the marital finances and didn't pay the bills, and the husband paid the bills from the very 1950s. And I think that is carried forward in the law right now, when there is no responsibility on the recipient to care about their finances. I mean, I am a person who was raised to care about my finances. I have a financial advisor. I save money. But not everyone thinks like that, and people have to think like that. Why should one person have to think like that for an ex-spouse who they may be divorced from for 20 years already?
Mm-hmm. And the
I think you're making a valid point, and I'd agree that there are some cases where people do follow that traditional model, and the male is the breadwinner, and the woman has not done anything regarding the finances. But that's not to say that the woman in that situation cannot learn to do so. And
exactly,
it's almost anti-feminist. It seems to be saying that this is a person who is incapable of taking care of themselves, absent any findings that this person is disabled or impaired in any way. We're talking about a otherwise healthy person. I would agree with you. I think it's antiquated.
That's right. Lori, do you want to give a shout out for your website and your phone number?
Sure. My website is www.barkislaw.com. My telephone number is 954-349-7988.
Do you want to spell that for everyone?
Sure. That's B as in boy, ARKUS as in Sam, barkislaw.com.
Well, thank you so much, Lori. I really am glad you called in, and I look forward to working with you in the next couple of months.
My pleasure, Debbie. Thank you so much for the opportunity.
Very good. And again, this is a statewide problem across the country, right? This isn't just in Florida. It's Jersey, Seattle, Oregon.
I mean, we don't control the laws in Jersey, but
it's a movement, and movements, you get it done here, and I guess everybody's going to want to do some movement here and more there.
Well, the interesting thing is some states already had fair laws, and Massachusetts was the most recent state to come on board in 2011, and our bill is quite similar to theirs, and that's what we're looking to model after.
Has anybody done this kind of fight for this reform besides you, besides you?
Yes. There have been other alimony reform groups in Florida, and I think they failed because they were too radical in their approach. They were anti-alimony, and I don't think that's fair, and I don't think that anything radical will succeed. It's just like it's maybe radical on one side now. The other side being radical isn't the right thing to do. I heard of a situation where a woman has MS, and she was supposed to receive $25 of alimony a month. Mm-hmm. MS. She's disabled. It's not fair either.
Yeah. Well, like you said, every room has a door, so there's a side to every story. So listen, this is an interesting. Since I've met you, I haven't seen so much stuff written about this stuff, and everybody's jumping on board, because I didn't realize how much this affected a lot of people.
Well, the more people I meet, the more passionate I get about this, because people like Tim and people I know, like I said, I have a 63-year-old friend. She is paying 65% of her net income to her ex-husband, who doesn't work. They were only married 13 years.
Gotcha. All right. Good enough.
Yeah, I got plenty to say, and some other time.
We
if
should do
you're
a special.
interested.
What we'll do is, as this thing gets more speed, we'll do a special and bring them in here. And
Well,
maybe some
Alan
of
would
the-
like to talk, maybe another time about
Sure.
the bill itself.
Oh, absolutely. I'd
and-
like to see that too.
I just think it would
be
be informative to your listening audience, so they actually know what we're talking about
Good
as
idea.
opposed to abstract.
good idea.
And so
What-
people don't get scared either that we're taking away their alimony right away, because that's not what we're doing. We're just trying to get people on their feet and independent. What people don't realize is how much better they'll feel about themselves by actually taking care of themselves and contributing to society.
And it's just providing guidelines so that everybody gets the same fair shake, no matter who they're in front of or where their case is being heard. And that, to me, is really important.
Excellent. Why don't you give us your phone number and website one more time?
All right, the website's Elkins, Elkins, and A-N-D Friedman, FREEDMAN.com. And the phone number's 954-772-6014 in Broward. And by the way, the main office is I-95 in Cypress Creek. And then we have offices in Palm Beach County and the Orlando area, and they should be on the website as well.
Excellent.
And it's funny, since Alan came out of the closet, so to speak,
I don't know about that analogy, Debbie, but thank you.
Okay.
Did I miss a segment here?
No, since Alan has come out and, for alimony reform.
I've got somebody for that, too,
All right.
when you go in that direction.
Okay, well, that's a conversation for another day.
There you go, another show.
Other attorneys have been contacting me, so it's interesting now. It's the family law section leaders do not represent the entire family law section in their viewpoint.
Okay. Well, it's going to get bigger, and I think you're onto something here. We just got to keep talking about it, keep mentioning it every whichever. I'm going to see if I can put you on another show besides the one that we put you on to try to get more steam in a different direction, and let's see what happens. I mean, the worst thing, we'll do this educational piece. I think is important, and we'll just let everybody know to call in with their questions. And again, litigation, you got to have a good litigator. You got to have somebody who knows what's going on.
But we also want to minimize the litigation.
You do. You want to minimize it, and you want to know that the money you're spending is well spent.
Exactly.
That you're not throwing it out the window.
I could tell you, I've talked to people who don't feel that way right now, and everybody's a little bit upset about the current situation, and it's hard to get a room to come together when everybody's upset. So, all right, very good. So let's take a break. I want to thank Alan for coming down.
Thank you, Alan.
My pleasure.
And we'll be back in 2 minutes.
Thank you.